let's start with the most obvious. I think it was actually the number one on the poll that I ran in Community in YouTube. Biden losing to Texas, Texas winning over Biden. So we discussed it briefly last week. Texas Attorney General filed suit requesting an emergency TRO, temporary restraining order, basically to suspend Biden's suspension of applying federal immigration law, suspending deportations, and the rest. That was one of Biden's, I think, what's he up to now? 70 executive orders or 40?
It set a record. I know that, Martin. It was an anticipated ruling for two reasons. One was because of all the precedents that have been set by the people attacking Trump over the past 4 years, where they expanded judicial power and judicial prerogative to interrupt or interfere with presidential executive orders, even as to matters of foreign affairs. So they're reaping what they sowed. The second part of it is that there was one of the smarter moves of the Trump administration on the way out was to contractually agree that they would go through certain protocols and procedures before they unleashed and opened the border, knowing that this would, in fact, hamstring Biden. And so that's a separate basis by which they could bring their action. Of course, also here, Biden is short-circuiting the entire internal regulatory process of notice and comment, which, again, Democrats were the ones to elevate and escalate the significance of in their attacks on Trump's executive orders, which were far fewer in number. And so just on those three bases, the court made the kind of, frankly, the obvious ruling. It was going to take a heavily politicized, openly hypocritical ruling to go the other way, given where they'd been ruling the last 4 years. And so it was not a surprise that he lost. I think it was a surprise, though, to some people in the Biden administration for whom they were just accustomed to winning, believing, to the people who are born on third base and think they hit a triple. There's a lot of Democratic lawyers that are on that side of the aisle and did not realize what they had set themselves up for. And so, and the Fifth Circuit has been stronger in this situation, and they didn't buy the standing and other arguments because it's clear Texas is directly prejudiced by opening up the border and not deporting those who've already been ordered to be deported. So given that they had as strong a legal claim as you possibly could, very smart case. Once again, the best populist state actor is the Texas Attorney General. He has been throughout this entire process, and he continues to be.
Now, the question I had, did anyone look into the judge? I mean, if we want to look for the political potential explanation of the judge, do we know who appointed the judge, who the judge was?
I don't. I didn't look at that. I didn't. Well, the ruling came down so quickly, I didn't go any further into it.
And I was going to do it. I meant to do it before, but I had too much other stuff to cram up on because you gave me a lot of homework this week. One thing, so first of all, does it go to appeal, or do they just craft a new executive order, which is sort of a two-part question? Am I not understanding it correctly that they can potentially just abandon this lawsuit, redraft another executive order, worded differently somewhat, and then require the Texas AG to go back to court to contest it again?
They could. If they're smart, they'll try to go through the internal notice and comment process, but they may appeal it to the Fifth Circuit. They can do so. Could take it all the way up to SCOTUS. But the Fifth Circuit has generally not been overly predisposed toward the government on some of these kind of questions. It's not a friendly circuit from a Democratic perspective. Obviously, the Supreme Court, they would anticipate, given its 6-3 majority currently, that they're not likely to prevail there either. And so just rewriting an executive order wouldn't solve their problem. And so it was a big loss right out of the gate. It was a big gamble, and it backfired in a major way, and it may put into a set of dominoes into motion that may hurt them in the other areas where you have the folks in the oil industry bringing a petition to review to challenge what happened in the Keystone pipeline. There's probably coming challenges to the CDC's mask mandate that are derivative of Biden's executive order as well. And so I think they've set things into motion that could harm them in the judicial system. They'd been presuming that the judicial system would be entirely aligned and allied to them because of how often it had been during the Trump administration, and they're discovering otherwise.
Okay, interesting. And so the decision effectively is, I mean, in a way, is a legal no-brainer where you have the executive effectively saying we're not enforcing the laws that the legislative approved of, and we're not doing it by way of executive order.
And we're going to ignore the notice and comment requirements, and we're going to breach our contractual agreement with the state involved. So it was the weakest claim. It was the most vulnerable claim for them to have tried to start out on, and it's evidence of the lack of forethought and foresight on the Biden administration's part that they stepped into it so quickly, so easily.
And so, I mean, I guess the issue would have been, but for this decision, the practical effect would have been exactly what the executive order dictated. This would have been effectively an executive order acting like legislation.
Exactly, and doing so in a context that not only did sorry, excuse me.
Let the jokes in the comment section begin, Robert. Yes.
Yeah. The not only does it do that, but they also just went at it in such a way that they had the least. I don't think they really planned on how to defend this and how they were going to succeed defending this, because of the way they defended themselves in court, how quickly they lost. They didn't appeal it right away. All of the signs were the signs of them just rushing something through. And in particular, it was problematic because you have these caravans coming up from Central America that think that Biden's executive order means they have 100 days to get to America and get free citizenship. So it was a major loss for Biden's administration right out of the gate that could have a detrimental domino effect, and definitely undermines the entire media legal left theory of the last 4 years, which is, oh, only Trump does these rogue things. It also reminded everybody what Biden said during the campaign, which he said a president who rules by executive orders is a dictator. And then he just set a record for the number of executive orders by any president, a record set of time.
It is, if anybody knows in the comment section how many it's been, I believe it was, it's either 40 or 70. I know that by all accounts, it's a record for anybody. The substance of these executive orders, I mean, how many of them are, I will say, over the top from a legal perspective, but how many of them are, totally questionable? How many of them are just guidelines that they're issuing for future legislation or for future administration action? I mean, what were the more egregious ones above and beyond the amnesty, or not the amnesty, the immigration executive order?
The one where he had the most authority but had the most immediate detrimental impact was the Keystone Pipeline one. But he had broad discretion in that area. So though there is a range of legal challenges coming to him, they're uphill battles. Probably the most problematic one after the immigration one. I mean, there's some ones about gender and critical race theory that are going to become problematic, but they haven't been institutionally implemented yet for impact. The one is that he issued a bunch of executive orders that asked for other agencies to issue mask mandates. And the most questionable one now is the CDC came up with a very broad mask mandate that basically they're trying to expand their jurisdiction and authority in ways that had not been done previously. Basically, all forms of public transit in the entire country, the CDC claims federal authority over. That's by itself extraordinary, and solely pursuant to the executive order by President Biden for them to do so. His fraudulency the second, for all those who don't know.
Robert, I was just going to say, you referred to him as President Biden. It was a show of respect.
Yes, but it has to be limited. We have to recognize his rightful title, his fraudulency the second, after his fraudulency the first, Rutherford B. Hayes. But the CDC is not only that, they're doing this double mask stuff. So one of my favorite memes was that the next thing Biden administration is going to come out with is just do saran wrap around your head, about 40 times. You might suffocate, but at least you'll keep that scary virus away from you. This is way beyond. I mean, they exempted, at least they recognized they didn't have control over private vehicles and private Uber vehicles, but public, but they even assert authority over taxis. So this is going to be challenged. The question is where it gets challenged, and the utility of it is the scope and scale of it is so broad, you can challenge it on grounds other than whether or not you don't have to prove to a court that the mask mandate isn't justified on scientific or medical grounds, though I believe you could incorporate that kind of challenge. But the other component of it is here you can challenge it because it's done by executive order. It's now done by legislation. They did no notice and comment period. The whole point of a notice and comment period, it's derogatory to the constitutional legislative power. But The theory is that the executive branch can kind of replicate the legislative process from a due process perspective by saying, here's what our rule is going to be. We're going to invite a lot of comments and then allow, and before the rule goes into force, and that's a multi-month process, they short-circuited that entire thing. The left used that tremendously against Trump in the census context and a range of other contexts. Well, if it's going to be fair play, unless the courts all want to embarrass themselves as utter hypocrites, which even federal courts have a problem doing it this quickly. You know, it's like Woody Allen's joke, tragedy plus time equals comedy. Well, for the court, hypocrisy needs time to look okay. And so you can challenge it on notice and comment grounds. You can challenge it on other grounds along those lines, similar to the way, and you can use the Texas decision as part of that predicate, because that was part of the premise for the Texas court decision to challenge it. And I think it will be challenged rather soon. You can also challenge it that CDC just doesn't have this authority in this many places. They're trying to make it a crime. They're trying to claim that the CDC now can criminalize whether or not you're wearing 2 masks, even if you've already had COVID and you now cannot spread it, even if you've had a test that shows you don't have COVID, doesn't matter. You got to have 2 masks on if you're going to use public transit. And by the way, who does this disproportionately target? It's poor and working class people. They're disproportionately imposing these rules on. So I think there's ways to challenge this because of its scope, ways to challenge it because of the lack of administrative process. It's the Administrative Procedure Act that governs these things, in part the notice and comment component. So I think that's coming, and that'll be a good, useful challenge to have, and maybe it can open the door to challenging some of these other mask mandates that are going far afield, which don't, frankly, have the degree of medical certainty behind them that their propagandist would propose. And part of the evidence of that is, why were they scared to do a notice and comment period? What was so afraid? I mean, aside from the time rush is the excuse, what were they nervous about? They couldn't justify this, maybe?
No, the time rush now, it's going on a year where masks they've been saying what they've been saying about masks now for at least 8 months. So, and I do want to specify 2 things. I get a bunch of emails after some of our streams, Robert, where people disagree with you, and they seem to come from, say, call them medical professionals. And I'm not saying that to be disrespectful. I'm just saying I have no way of vetting any email that I get, but some people disagree with you strongly on the masks and some of what you say. And I actually just want to specify that when Robert says this, my impression, and I think I'm not wrong in reading it this way, is these are the arguments you would raise if you go to court. And so this is not a lawyer pretending to be a doctor for everybody out there. This is a lawyer saying, if I'm taking this case to court, these are the arguments I'm raising, and this is the evidence and the studies I'm going to raise. And it'll be up for a judge to determine whether or not it's compelling enough. But these are the arguments. So I want everyone to appreciate that this is not a lawyer playing doctor, which is like the old joke. What's the difference between God and a lawyer? God doesn't think he's a lawyer. So I wanted to open that parentheses. And while I see this.
And here there are 2 other issues. So independent of whatever you think of masks and their utility and efficacy, for which clearly there's controversy. Just go back and look at what they were saying in February and March of last year, where all the mainstream media was bashing the idea of masks. Did the science really radically change within a few months? So that would be my open question to those folks. But there's additional problems on the mask side. It's just, why are we requiring it of people who have already had the virus? Why are we requiring it of people who've been tested negative? Why are we requiring it of people who are asymptomatic? Because now there's more and more evidence that there is no massive asymptomatic spread, as was falsely alleged. So it's who's being required to wear it. That's also a problem, aside from whether it's effective, period. But putting that aside on the mask efficacy, do you want the CDC to be able to regulate your local town hall? You're supposed to, these kind of decisions should be governed by your local government that's most responsive to you. It should not be the CDC. So the problem is the degree, the scale, and the scope. And where do you think this ends? Do you think this ends? So even if you believe in masks, do you believe the CDC should have this power? Is the big question. And then a secondary question to that is whether they went through the proper process in the first place to even institute it. And then last is whether the masks are effective or really required for health purposes. The hard part is I've been explaining to people about challenging masks other than challenging them in the disabled context where it's discriminating against people who can't wear masks, is that the courts love masks. So if you show up in court, you're going to have a bunch of masks on. So there will be an uphill battle convincing judges that the white lab coats don't have it right here. But there's plenty of evidence that from an evidentiary presentation perspective that it isn't. And my belief is if you had both sides present their experts, an independent jury that came in with no bias would decide that the masks do not meet the constitutional standard for coercing it and compelling it on people. No problem people wearing masks. I'm not telling people not to wear masks, whatever you want. My view is freedom first. And that's the main objective here.
And this would have been my position from the very beginning is without requirements, without legal requirements everywhere, I think you'd get upwards of 90 some odd percent participation because people have no problem doing it by and large. Where people start to take issue with it, as is the case in general, is when the government starts making it legally mandatory. Then people start pushing back more than they probably would have in the first place.
And we've already seen it's disparately hurt discriminated against the disabled all across the country. They've been mocked. They've been humiliated. They've been attacked. They've been verbally attacked. They've been socially attacked. They've been denied and deprived services, denied and deprived access to education, denied and deprived access to employment. So we've already seen the detrimental effect and impact of coercing and compelling this on the broader culture. It disproportionately falls on the least able to protect themselves for people who are already exempt under the law from having to wear it in the first place. Aside from I'm just not a big fan of medical Sharia law, so I'm just not a fan of it, period. If you're right, you should be able to use persuasion to get people to do it. And as you know, 90% of the people do so if they're persuaded of it. If you're wrong, it's only when you're wrong that you really have to compel and coerce people to do something because you weren't able to persuade them. And if you weren't able to persuade them, you shouldn't have the backdrop or the second option of being able to force that medical Sharia law upon them.